But was it the thinking of the politicians at the time that the Charter would be a living document that would evolve as society thought differently about equality rights?
Absolutely. Absolutely. And I think the next Chief Justice, Brian Dixon, talked about the growing tree doctrine. And this is so much different than the Justices Scalia and company on the Supreme Court of the United States who talk, they have this originalist approach and say, well, no, we're going to, and we've got to decide what the drafters of the Constitution meant. And they rejected the growing tree doctrine in our own Supreme Court, which makes, of course, a whole lot more sense.
Do you recall any discussion of racial equality at the time?
Well, it was assumed that racial equality, that the Section 15 prohibit discrimination on the basis of race. I mean, that was right in the original draft. That did not have to be read in by any of the courts later.
Okay. In the last 7 or 8 years, there's been a chorus of complaints about judicial activism, and they're usually directed at charter judgments. Did you and your colleagues foresee this, and do you believe the courts have overstepped their role, defining rather than interpreting law?
Well, as having served as a Chief Justice for 16 years, I'd be reluctant to be critical of the judges, nor should I believe that they be criticized. I want to emphasize the point that I made earlier, that the elected parliamentarians, they handed over this responsibility to the judges. We did not, no judge ever suggested it or requested it. But we realized, speaking as a politician of the day, that we were embarking on uncharted waters, and we could not predict with any certainty as to how the courts would react to this important new responsibility. But having practiced in the courts for many years before I entered politics, I had a fundamental respect for the courts with respect to behaving responsibly. And there'll always be criticism of judicial activism, but I don't think it's justified. Some judges make mistakes, and that's it's always been that way. But I think we've created a very good balance between the elected legislatures and the courts. And I think there is a degree of mutual respect, and certainly judges don't want to be thought to be high-handed in interpreting the Charter. But it also should be emphasized, and I know we're running out of time, but it should be emphasized that the Charter of Rights is for the minority, not for the majority. The Charter of Rights is fundamentally a document to protect minorities, and the majority of Parliament are there to protect the majorities. So that's the fundamental difference.
Thank you very much, and I'm afraid we have to wrap this segment of the program up.
Nice to see you as always, Carol. Yeah. Thank you.